Good afternoon, everyone. This is the Vermont House Committee on Conflicts and Economic Development. It is Friday, February 14th, 2025 at 2:30 in the afternoon, and now we're back to take a look at another redraft from our legislative council with Sago. Rick, you've been doing anything this afternoon?
Just waiting for you to call me back. No, okay, sure. Rick Sagal, Office Home. Rick Sagal, Office of the Council. Yes, I apologize for, I don't apologize because I could not have been here. There's no way of doing it. So I am mid-draft. I will show you what I have. A few things I need your assistance finalizing. Again, I didn't hear the last discussion completely. So I may be a bit behind where you all are. Let me close on my windows. Save changes now. Okay, this is 342, right?
Yes, not 243.
Which just passed. Like, why is it back to back to back to back to back? Okay. 2, 3, 8, 1. So this is now, and I have not sent this to Anna Grace because it's a work in progress, but your last version was 1.3 or 4. Okay, so now we're on 1.4, and that's what I have on my screen. And again, once we have this fleshed out, I'll email it out and you can have it on the webpage. So I've made no changes to, again, the findings and purpose. We go down to the definitions. And by the way, I've unhighlighted things from 1.3 that I thought the committee didn't have any issues with. So for example, we have covered persons, including federal law enforcement. I think that was okay. Based on what I heard, tell me otherwise. 3B is where I'm running into some problems. I understand you want to protect employees, definitely of the Family Service Division of DCF, the Vermont Human Rights Commission, and we previously had just those two in this one. I have added the Department of Corrections as an entire entity of employees. I've added DPS, and I've added the Department of State's Attorneys and Sheriffs. So employees, right? This may not include contractors. This may not include people who are, work hired by a third party. But then I know Department of Corrections has some contractors that they employ, and they're not employees of the state. They're employees of the contractor. Are you first okay with these entities being listed as employees of being included as covered persons? And did I miss any entities you want to include?
Okay. I mean, it covers folk, the people that I was thinking of.
Okay, then.
Question. At what level of picking the nit are we going to right now? I see a typo and I don't know if you
Is it-
need to know that right at this moment.
I just fixed it. I just fixed
You
it.
did just fix
I just fixed
Thank
it.
you.
Move on.
What?
I don't know.
And it doesn't hurt me to phrase my question.
It's not an official draft. It's a full-
Super Rick, got it.
Yeah.
Cleared up.
As I had a second to think about something, I saw the typo. And so these 5 are okay. Then on subdivision C, we're not talking about non-employees. We're talking about investigators, victim advocates, mental health crisis workers, and embedded crisis specialists that are employed or work on a contract basis for any of the entities listed in 3B, which are these 6.
Is our Defender General's investigators covering?
So would they be considered court staff? That could be a gap, right? I don't know. Do you want to list them out specifically?
Want to slow down the train. But at some point,
I think they'd be court staff.
an investigator of the Defender General's office?
Are these defined terms in statute?
Court staff is not. That's my problem with court staff. No, I think maybe you're right, Herb. I think Red Wilson, I think maybe, yeah.
I don't, to hold this up, I mean, I'm confident, we'll get another crack at this, so. Can we find that later on?
Continue. Okay, are we okay with the added investigators? Are you okay with these groups included in B?
Did you want prison guards?
I'll wait.
Public safety?
Or DOC, right?
I don't know, correct, yeah, third, fifth. Okay, I just know Herb had that earlier. Okay, cool.
It still doesn't get at contracted employees of municipal law enforcement professionals, right?
Forgot that one. Okay,
Just
let me see what's here.
Anyway.
Okay.
There was a list of employers. And then you said investigators and employers,
Yes,
and I think you had state's attorneys and AGs.
let me go back up.
And if you just included state's attorneys, AG and defender generals or something.
Well, the AG's office is not included in this, like, specific grouping of entities.
But that's more complicated.
I think good is good.
Yeah,
And
that's
it's not gonna be perfect.
that's what I was saying, thinking, that's fine.
Let me skip ahead to the chairs.
So before we probation and parole officers work for the Department of Corrections.
Oh.
And parole board is a quasi judicial. Board's independent, impartial. And from Mary Jane Ainsworth. I think you just got it too, Rick. You can take a look at it.
Would you just say public employees?
So there's a definition of public agency I could cross-reference, and that's basically every state, municipal, town employee. If you want to go that broad, you can go that broad.
I mean, we've gone this far. I mean, it's not without, so man. I mean, there is a legitimate reason why even public works folks, right? Because perhaps they cross somebody as they're doing something on the public works side. And they also could fall in line with that.
Sorry, I'm talking about.
Just as legitimately, I'm not trying to. And it might be easier just to say that versus like list people out. Although, no, that's not true because it would still be on the website. So you would have to, never mind.
I sort of see this bill as trying to provide some protection for law enforcement. These kinds of things. That's just how I see it. Sort of,
They covered when you say municipal employees up there.
yeah, I know. But my conception of the bill is
Yeah, that's the stated purpose.
the fundamental purpose is to protect folks that are involved in law enforcement. That's just the way I see it.
I was trying to make it easier. I don't,
I'll explain what I'm doing here. I know you're percent. What is this guy doing? I saw the email, Mr. Chair. They still want them to be protected, but they're not officers. So I added the members of the parole board up to 3A instead of down to the definition of parole or probation officer. That's what I just did. I'll highlight that as a change. Back to your municipal employee, a couple of ways we could do this. We can go down to
Probation and parole officers fall under Department of Corrections, right?
Correct.
So where, where, where is that sitting with,
The parole board,
no, parole officers?
there, so we have the definition here.
Yeah.
They're listed up at the top in the group. Right here.
But wouldn't they be part of the Department of Corrections as well?
You have some overlap here. Yeah. Yeah. That's if we're gonna be specific in some places, you're gonna, yeah.
Okay.
Municipal employees. We can either go down here to the definition and say it means what we have in statute and also includes individuals who, how do you want to word that? What's your idea?
What is under 1722?
Share my entire screen again. Okay, so 21, 17, 22. So municipal employee, this is where we are, right? I have the right one?
That's all, it's
Yes.
all municipal employees, right?
Yeah.
And it includes elected officials, board, commission members, executive officers, individual employees.
Doesn't include that except A, B, C, D, E. An employee of a municipal employer.
Except.
Except
okay.
A, B, C, D.
To understand the school component, we need to check out 1735 for what a certified employee of school districts. I'm getting, I could use some help from Edge Council understanding 12, the except E. So municipal school employee except.
What a certified employee of a school district, what that is.
Yeah, I'm just getting something.
I'm also confused by this.
Yeah. So what I would suggest at this point is not cross-reference this. This is maybe more complex than was intended to be, and just say it's an employee of a municipal employer. And we can define that. In fact, I can steal this definition here that you have in 13.
Any political subdivision in the state.
Let's just go back to the purpose and for the purpose of for people that are in law enforcement, judges, law enforcement, parole. And so if we want to stick with that purpose, I think you would just define it as employees in the municipality that are providing law enforcement or, whatever we're talking about here, right? I think that we really tighten this up, so it's.
The original adding the municipal employees really came about because of poll workers getting threatened that are not elected. So but it's, if we need to remove that and or limit it, it's totally fine. That is not in the other states, so
Yeah, when we start going down.
yeah, totally.
Then you look at elected officials, and people that sit on select boards or.
It's
council.
non-elected officials.
I know,
Yeah.
but
Yeah,
you know what I'm saying?
yeah, totally.
So law enforcement includes, town, county law enforcement.
It does.
Yes.
Okay,
So
so we're good there.
So yes, so
Law enforcement officer, okay.
Take out municipal employee.
that's my recommendation.
Yeah, me too.
If you don't want to deal with that complexity.
Yeah.
And again, up at the top, I think.
Note this, I need to change this number. Thank you. Okay, so we're back down. This didn't change from last time. This didn't change. This needs to be 14.
Back to this. Can you, scroll back to, disclose again?
Mhm.
Do it later.
Okay, so any more questions about the definitions? We all good there?
I remain concerned about the inadvertent or the malicious penetrating of somebody's database, a broker's database, and doing it. And it's their data, but somebody else has accessed it. And I don't know how you deal with that, but I just want to go on record saying that's a concern.
Subsection B, so we have the same notice, 15 days shall cease disclosing not later than 15 days after receipt. That notice is provided by the Secretary of State. No changes there. The remedies, no changes. 15 days, you have an injunction. 30 days or later, you have other remedies available to you, monetary, punitive, and so forth, if the court deems those worthy. Diligence, this information, limitations. The last change I made, based on what I heard from the committee, is I added a new section saying the remedies in 9 VSA 2448 C1B. What is that? Shall take effect January 1st, 2026. That is the 30-day remedy, this one here. So this subdivision that is in this law would take effect January 1st, 2026. So I think the intent is like a 6-month window for data brokers to understand the requirements of the law. The injunctions can still happen on day one of the effective date, July 1st, or 15 days after July 1st. But the 30 days would take effect on January 1st. And all right, those are the changes I made. I may have missed something in my haste to move around the last couple hours.
Couple things. Number one, signees. One of the things I've heard is that this word is what really enables a lot of these trolls to really get into this PRA. They'll send a mass email and say, hey, just assign your rights to us and we'll take care of you. What are the ramifications of removing assignees?
So if you did not have the ability for a covered person to have an assignee, then either they or a lawyer that they hire would have to bring suit on behalf. When you have an assignee, you can, go through a company that can facilitate that arrangement for you. So it makes it easier for the covered person to go through the process. I'll put it that way.
But not having that makes it harder for a person who potentially would be doing these frivolous lawsuits to do it.
So it'd be harder, right? So the assignee, the companies, right, that may do this as a business, would obviously not be able to do that. They would not be able to be assigned unless they were a law firm, and that's what their business was, to represent people. But yeah, it would remove that aspect of it.
Okay, I would feel better about this if that was removed. The second point is the penalties. It says of $1,000. What if we were to make that up to 1,000? And my reasoning behind this is another thing I've heard is that a lot of these data brokers are trying their best. This gives a judge to say, look, okay, maybe you could have tried a little harder. but we're gonna cut you a break. How about only $100 or a couple $100 to recognize the fact that they at least tried?
Right. So it's up to the committee. Liquidated damages are set, so we'd have to change the wording. Because when you say liquidated, it's like this is predetermined. We determine the Vermont Assembly assumes this is the harm. This is how much it should be worth, $1,000, unless you've been harmed greater than that. So we can, if the committee wants, we can amend this language to kind of reflect that idea that it could be up to 1,000. Is that what you're?
Yeah.
Or a different number? Whatever the committee wants to do on that, that's an option too.
And my third thing on that is, what about saying actual harm? So in other words, you wouldn't be able to sue for damages unless something actually really happened to you.
Well, that is kind of how the court system works, right?
Mhm.
The judge, the jury is going to determine based on negligence if there's been harm. There's no harm, there's no remedy.
Gotcha.
But to go back to you, the greater, if you've, as an example, let's say that you have been harmed. Let's say you're a covered person, right? And your data's out there, you send a notice, they don't take it down or they don't stop disclosing it. Let's say you go to court and you show that because my data was out there, I've been harmed because of X thing. And the judge says, you know what, that's worth about $500. If this law were to pass as written, you would get 1,000 because it's worth more than 500. If you were to be deemed to be harmed, $20,000 because you couldn't buy a home or something, right? Whatever the harm is worth, right? You could get the $20,000 instead of the 1,000, right? Because it's greater. So, or you get zero. Let's say your harm is worth zero. This law would not allow for that because there's liquidated damages. And again, there has to be harm though. There has to be some kind of harm for the judge to order that they've been negligent. They didn't do what the law told them to do. So you've been harmed. Therefore you get, again, 1,000 or whatever the greater harm is. Does that make sense?
Yes.
Okay.
Thank you.
Yeah.
The hidden costs in this section, isn't that? It's the attorney's fees and other litigation costs as reasonably incurred. That's where the big money starts coming in.
Again, deemed by the court, right? So the court a lot of times will award attorney's fees, especially unless it's a frivolous lawsuit, right? Let's say that you are like a covered person says, you know what, my data was not removed and I've been harmed, and files a lawsuit against 20 data brokers. And let's say it's frivolous. That plaintiff would not only not get his or her attorney's fees, he may have to pay the attorney's fees for the other side. Even though the law doesn't say that, courts are able to do that on their own. They can say, you know what, this is pretty stupid. You shouldn't have done this. You owe attorney's fees. So the statute helps the courts determine what it can and cannot do, but it can do more than what the statute says, if that makes sense. It can order things that are not clearly specified in the law. So the defendant can also ask for attorney's fees, that, hey, you got to pay for my attorney's fees because this was frivolous.
I think I may have been under misapprehension. Could you clarify what we demonstrate what harm is? What you just described sounded like it isn't simply the evidence that I asked for it to be marked private and it was not. There needs to be more than just that.
So it's negligence. In this case, it's negligence.
And I'm sorry, in this case.
So it's in subdivision 2 on page 8. In any proceeding, the standard of fault should be ordinary negligence. What that means is that the data broker must have done what a reasonable person would not have done. And let me try to, if a reasonable data broker gets a request to cease disclosing a covered person's information, and does not, hold on, the ordinary negligence means what a reasonable person, or in this case, data broker, would do. So you can kind of see there are some maybe extremes here, right? So if they receive 5,000 cease disclosure requests, and I think that came up, right? Like, what if they get bombarded with requests? Would it be reasonable for a data broker to take a bit longer? Yes. You can make the argument that's not negligent. That's actually reasonable, that you couldn't do that. If you got one request and you didn't do it, that's probably not very reasonable. You could do that. But if you tell the court, hey, these systems don't allow us to do it within 15 days, we have these barriers, whatever they are, you know, we couldn't delete this person's, or sorry, cease disclosing this person's information within 15 days. You could argue to a court, this was not negligent. We just couldn't do it. It's impossible. So as opposed to strict liability, which would say, we don't care if you were negligent or not. You violated this law. That's not what this law says.
E1
Mhm.
has the greater of actual or liquidated. And subsequent to is punitive, 3 reasonable attorney's fees, 4. However, then 2 super. This might be an area where I need to really go to church on this. Like what? So 2 does. How does 2 impact 1? It sounds like that's what you were getting at with the negligence.
Yeah, so in any judicial proceeding pursuant to subdivision 1, which is up here, right?
Yes.
It's either the injunction or the monetary relief. In any judicial proceeding, basically in this bill, the standard defaults to ordinary negligence, as opposed to, like I said, strict liability.
So when you send in on day 1, when you seek a remedy, the data broker receives some notice that a covered person, that protection information has not been adequately protected. Does that person then need to also be sure to demonstrate harm? And that's what I want to make sure that is clear for the covered person.
Mhm.
Hey, I can see that my information is still out there. You got to get rid of that. That covered person doesn't also need to say because some harmful thing has occurred.
Well, you must, so you're the plaintiff, right?
If I'm
So,
the plaintiff, I'm
yeah,
a covered
you're the
person.
covered person.
Mhm.
So you have to show that the defendant, the data broker, violated the law. And the standard that the court will use in that determination is negligence. So the burden of proof is on you as the plaintiff to show that, hey, this happened. I deserve relief, either injunction or otherwise.
This seems like an important check then, because earlier it was like you don't have the data broker cannot ask for verification, but that you are or not a covered person. They have to default accept that assessment.
Right.
But if there has to be harm beyond disclosure, and that's what maybe I'm getting tripped up on here.
Yeah. Well, the harm is the disclosure.
Okay, thank you. That
Yeah.
was really the thing I needed to
Yeah.
understand.
Yeah.
Thank you.
Okay. Sure.
Okay.
Sure.
All right.
Yeah.
Thanks, sir.
Yeah, of course. No, that's okay.
How difficult is it then to prove negligence in a situation like that?
It depends, right? It's fact dependent. And it's up to a jury of 12 people or 6 people or a judge to determine what they think was the standard course of action. So if, like I said, I can give you examples, but again, it's just so fact dependent. And in this area, it's going to be kind of interesting to see what a judge would say. Is or is not negligent, as to, you know, your standard should have been, yes, this is a reasonable thing to do, or no, this is maybe not reasonable. So you weren't negligent in your duties. Because this is setting the standard of care, right? This is setting the care to be 15 days, right? So if a data broker does not do that, you know, is it a negligence? If they do something that was negligent in not meeting that 15-day period or 30-day period, whatever it is, it's going to be up to the court to determine that. And it's a reasonable. That's the best way I can explain it. Did I miss anything else as far as the changes that the committee?
It's in there. Yeah. Yeah.
The effective date, so no, I added a section,
Second.
a delayed start, saying that that specific 30-day section that takes effect January 1st, 2026. Well, that's the changes I made from draft 1.3.
it one step further. That in order for plaintiff to file the suit, they would first have to file an injunction.
So a suit is, an injunction is a suit. You know, it's just a different form of relief.
Yeah. But they would have to,
Oh, they'd have to file an injunction before they can request.
Do a,
then, I mean, then you have a data broker that is not responding to an injunction ordered by a court.
Yeah.
That should give you stronger grounds to be able to go after them.
Think you're trying to alleviate my problem. And I just need to know. Because and I don't understand it, and I think that I like that. Not that I don't understand it, but that you're trying to alleviate my problem. But I might be wrong, you might not be trying to alleviate my problem. So what does that do? Because I don't know the process.
So you file something with a form or some type with the data broker.
Okay,
They have 15 days to remove your information.
okay,
They don't do it in 15 days.
okay,
You file an injunction.
okay, so what's,
So the court grants your injunction. And right now, that's just optional. Right? So if you don't file the injunction, then in 15 days after that, you can file suit. So what this would say is you have to file that injunction in order to be able to file suit.
and so
So the injunction is a court order,
okay,
and if the data broker does not comply with the injunction, then you have now the ability to file suit.
and the data broker at that point of the injunction could say, hey, they submitted a boatload of these. And then the court would determine, well, you have to fix it by this date. Right? Is that how that works?
That's right.
Sorry. Repeat the question. I briefly
So-
looked at my email.
So we got 15 days in there.
Yeah.
Right?
Yeah.
And then the court, the injunction is filed.
Talking about the current bill
No.
or the idea.
The idea.
Well, I mean, at any time. So if I file an injunction against a data broker.
Right.
They can respond.
Right.
If they choose not to respond, then the injunction is granted, I'm assuming.
By default, yep.
Right, but if they do respond, they can explain their situation to the court.
Mhm.
And the court could say, you have X amount of days to do this, right?
Is that correct?
So you would file a suit and you would be limited to injunction at first. And you're saying that the person would then, once the injunction is granted, then they'd be able to file for additional relief? Is that what you're,
If
if it's granted,
well, if the injunction is granted and then
they continue to
it's
disclose?
ignored,
Okay.
right?
And your question is?
So, I mean, if you get a court order and you ignore that, and they took into consideration of, a boatload of requests, and they looked at it and said, hey, you can do this in time. That I would feel comfortable with, and then that gets rid of the game of submitting a bunch of complaints, wait 15 days and then sue. Correct?
30 days, yeah.
Well, 30, whatever, yeah.
So if you're talking about a one data broker getting a bunch of complaints and they all get filed this on the same day, right? And the court may or may not hear them all at the same time. It depends on how common the claims are. And you're wondering if that decision the court makes gives the businesses more time to comply? Is that what you're asking?
The court could make that decision.
The court could, sure,
It
yes, yeah.
Could make that.
We're just
decision.
saying that the court has, you have the opportunity to request an injunction. The court can always say, no, this is bad, you don't get an injunction. But the court could also, you have to give the court some, leeway here in deciding what they think is best in the situation they have. Yeah.
I mean, that makes me feel a lot more comfortable. And I think there was a clause in there that allowed assignment of claims. Is that correct or no? Yeah, so I mean, I'm thinking of the situation where, there's entities that are doing this intentionally for fun. Or not fun, I shouldn't say for profit, but for profit.
Okay.
So what we just did with that idea, you ended that. Right? I mean, they can still do it, but it puts a person, puts the court in the position of saying, data broker A, you're saying that it's gonna take this long. Okay, but we think you can actually do it sooner. And that means that there's no lawsuit there. Right? Am I understanding that correctly? Is that correct? Am I?
So I can't say, I don't feel comfortable saying that exactly is gonna happen because I don't know this business. I don't know how they work. I don't know how they make their money. I don't know. That's kind of been outside of my experience, but I will say, the requiring the injunction before filing for additional relief would slow things down.
The speed bump.
So I think the main the conceptual difference between the two in the bill is drafted right now, I think it's triggered by a notice. And a notice, you fill out a form, right? And so there's not a whole lot of transaction costs involved in that. Litigate, filing, getting an attorney, filing for an injunction is a little more complicated and expensive. And then, as Rick said, might take a while too, depending on the calendar of the court, not everything's heard right away. So I see those as, kind of these sort of transaction costs, what's going to trigger the ability of an individual to gain relief for violation, and how much does that cost you? I know perfect good, but one of the suggestions that if this goes forward the way it is, I'd like to pursue is this notion of a gatekeeper role kind of thing for the AG, which might perform a similar function, but not have the same expense for the individual covered individual. But again, I'm not bringing that up because it would take a little time to draft that.
A suggestion, I agree, on that. Can we attach so because it could cost like 10 grand for the injunction or whatever, it can be expensive. If we attach reasonable attorney's fees to the injunction that we're like saying, that the court decides as reason. Okay.
We're happy.
Okay. Okay.
How does that differ from what's currently? Is that not provided for? I guess.
So we're adding like a whole level, we're adding a different level of the suit. So the reasonable attorney fees is on the full, Rick might, or Herb might be able to better explain this, but yeah, we're doing the reasonable fees on one piece, but not on the other piece, which is now an expensive step for the individual.
Or the individual assignee.
Right.
Yeah, okay.
Yeah. But reasonable as determined by the court. So it's not like, yeah.
Nice.
Yeah.
Yeah, I'll just add, I feel like if we're asking a corrections officer to spend that much money, they're not gonna Yeah. It's just, it's too big of a, it's friction, but I think it's friction in the wrong place. So I appreciate I don't want to clog up our courts. None of us wants to clog up our courts. We have to think, yeah. I'm not sure this is the place that does that.
And on that note, it may be something that we deal with what were they called? Not, I guess, agents, the authorized agents, maybe we deal with that separately. Because, because the issue of authorized agents and PRAs, like, it keeps coming up. And if there's a concern that there are these actors that are interstate that are just bringing loads and loads of frivolous lawsuits, then maybe that's something that we just deal with separately.
One of the things that we had been thinking about is we have the consumer assistance program through the AG's office at University of Vermont, and perhaps there's a way to get them involved in this, and that's not going to cost money.
We actually looked at it.
Yeah.
That's protection.
So I don't.
To help
that we
with
have-
education, yeah.
To help
Or
with,
no, the cat.
to help,
Cat's each.
to help with, slowing down frivolous lawsuits, right? So if you have you have the step there. Again, timing, I'm not sure we have right now, but I think we can send our ideas to the Senate and let them know what our concerns are and give them that opportunity to help fix it.
Yeah, I think if we're gonna make that change with the AG stuff, she tried to call me. So I think if we make changes to the AG stuff, we should hear from Charity again. Like if we're gonna do that, I would rather not. Yeah.
So what's the decision on that timing thing? Are we good with the way it currently is, or do you want the 15:30?
Yeah, I'd like to keep as is with the edits that you made in 1.4. And send message to Senate, like additional changes.
Comfortable with draft, as Rick explained, there are a couple areas that I think would benefit from our additional work. And I'm confident that we'll be able to do that.
So, I mean, I'm not comfortable, but that's okay. What I do wanna, I think what I'll probably do is take some advice. And I'll probably work with Rick to see if I can get an amendment that would make me feel more comfortable. That I will introduce on the floor. Obviously after I bring it here first. Get probably a town vote on it, but that's okay. Who knows? We'll never know.
We will.
But we will know eventually. Yeah, we just don't know now. But that being said, I just want to give you guys a heads up of the stuff that, and I appreciate the suggestion. Yeah. Maybe I'll do it for my other bill. That's not here.
Right, that's right.
Yeah.
So,
Yeah.
yeah, is there anything else that I gotta read? Maybe like an idea of where people are on this. I'm not really want to bring a bill out that didn't have strong support from the committee. Yes, everyone in favor at this moment, raise your hand. So we're 7-4. Let's take a 10-minute break and come back. 3:25.